All right, good evening and welcome to the Town of Douglas Planning Board meeting of Wednesday, December 10th, 2025. This meeting is being recorded and broadcasted by Local Access Programming with remote participation available as provided on our agenda. I hereby call the meeting to order at 7 p.m. Members in attendance are Jacob Schultzberg,
Meg Schlesman,
Mike DeRose,
Rich Preston,
Mike Zwicker,
Jake Gnatic.
and I did hear from Mr. Sokrat, and he is excused, and Mr. Greco is here.
Yes.
No A&Rs, no public hearings. Moving right along. Woodland Road, Deer Crossing, definitive 030612, final phase. Peer review, discussion, possible votes. Margaret?
Good evening.
How you doing, Margaret?
Very good. Margaret Bacon, Civil Site Engineering, and I'm here representing the Woodland Road development regarding requesting the planning board for allowing us to use Graves for a stormwater peer review. I don't know if any of you here are familiar with the Woodland Road Estates. This is the final phase. This has been an approved subdivision that was approved back in, I think, 2004 and A&Rs in 2018. So this is the final phase of Woodland Road. There's about 6 or 5 more house lots. And so we still need stormwater to be reviewed, and the Conservation Commission's reviewing the wetland impacts and the notice of intent, but they don't have the vehicle for the stormwater peer review.
Okay.
And I think Graves was involved in this.
Yes.
They were.
We have letters from them in the file from the past. They've done this.
You're familiar with the project?
Yeah.
Okay.
And also, we do have a 53G account that's still active for this project with some funds in there, so we do have some funds already ready to appropriate towards this.
Okay. All right. Any issues with this, John?
No, like I said, this is pretty much just a formality for Margaret to request the use of Graves. Like I said, they've been used on this project in the past, and we do have a 53G account that's already active with funds in it, so we're good to just continue on.
Okay. All right, with that, I'll entertain a motion for Woodland Road, Deer Crossing, definitive 030612, final phase for peer review through Graves via 53G.
so moved.
Second.
Made by Mrs. Zwicker, second by Mr. Preston. Any further discussion? All those in favor?
Aye.
Okay.
Okay, thank you.
Thanks, Margaret.
And so I'll get an estimate from Graves.
Sounds good.
Okay, very good.
Thank you.
Thank you. Yep.
Have a good night.
Okay.
Can you pass that around?
Yep.
Will everything pretty move quick until the ADU discussion?
Yes.
Okay. All right. Covenant, the lane at Hunts Pond, definitive 160628.
So the background on this is the lane at Hunts Pond is a definitive subdivision that was approved back in 2017 by the planning board. No construction ever started on it. When I was contacted months ago, it was going to be purchased by Afonso Real Estate Development. And I checked with town council and Jay Talman at the time, and with all the tolling periods that have happened since then, it is still an active subdivision. Its approval is still valid, decision is still valid. So it was just a matter of executing a new covenant for the new owners. And my office is holding on to the signed Mylars because we are not allowed to release them until we have a form of surety in place. So we're still holding those Mylars. So before you tonight are the attorney for Afonso and Mr. Afonso, and to introduce themselves and just as a courtesy to kind of tell you that they're now on the project. And coming out of this, we're going to have a new tech review meeting because there's been so much turnover in the last 7-8 years. So just and I'm going to be meeting with Mr. Afonso to go over the conditions of approval to make sure that this moves forward properly.
Okay.
Okay. Good evening, Mr. Chairman, members of the board. My name is Suzette Ferreira. I'm an attorney in Milford, and I represent DNF Afonso Builders. With me tonight is Dominic Afonso, who is the owner of DNF. We got involved in this because my client is trying to purchase the lane at Hunts Pond, and as we started going through this process, we discovered that the subdivision was approved back in 2017. For whatever reason, the existing owner never completed the process to get the Mylars released, and the Mylars continue to be with town planner. We did have many discussions with town council just to confirm that the subdivision was still valid. However, what actually happened is the covenant was signed by the previous board, but the seller never the existing owner never signed the covenant. So the only signatures that are required are the signatures of the existing owners of the Hunts Pond subdivision. So that has now been signed. So we're here because the existing owner wants to sell to my client because they don't want to be responsible or have the obligations under the covenant. My client is purchasing the property, and he understands that all of those obligations are going to be his obligations. He's obviously read the subdivision approval, he's read the covenant, has reviewed the plans, and he understands, what he is going to be taking on. And as John said, we've already had discussions that after he's able to close on the property, because we are unable to purchase the property without the Mylar plans, because we need the Mylar plans to describe what he's actually purchasing, because that sets boundary lines than what is existing currently. So until we can record the covenant and the Mylars, my client is unable to close and actually purchase the property. But once we do that, then we let John know that we would follow up and take whatever steps are necessary to move forward with the subdivision. So I just wanted to introduce ourselves, give you a little bit of history and background as to how we got here, and what we're trying to do moving forward.
And the board should know that Attorney Ferreira has worked with Brian Winter,
Yes.
our town council, until
Yes.
recently. In fact, he stayed on even after new council was chosen to finish this project, and he's approved the content of this covenant that's legally acceptable.
Okay.
So that has been done, and emails went back and forth that I was privy to. So Attorney Winter has authorized the content and the form of the covenant.
All right, and this was approved, looks like, a couple months before I got on. Just a reminder, how many lots is it?
26.
26? Okay.
And question to John, if anything has changed legally with stormwater regulations, anything like that?
They have to comply with current regulations. Yeah. Because even though the subdivision approval locks them into zoning, but they hadn't started construction yet, so they have to meet all the current best management practices, all the current stormwater regulations, because construction was never started.
Okay. Will we have to review the plans again?
No, but from what I understand in talking to Mr. Afonso initially, the roadway was approved to be constructed in 3 phases. It is my understanding that his interest is to construct it in 1 phase, which they would have to come back for a modification to their phasing plan. In speaking with Adam Furno, the highway superintendent, and also Ken Frazier, our building commissioner, that is actually a preferable thing for the town, is to have the roadway constructed all at once. It will make the process go smoother. So again, I anticipate, once we have the tech review meeting and all the preliminary stuff done, that they would come back for a modification sometime in the next couple months for that phasing plan to be 1 phase, and we get a modified plan.
Okay. Board, any questions? All right, so what do we need from us?
No votes, no signatures.
Okay.
This was just to make the board aware of it and kind of introduce the project again, because again, it's been almost 8 years. So just to know that this is going to be starting up, and they'll be coming before you for that modification.
And also to be able to release the covenant and the plan so that we can get those items recorded.
Yeah, that I can do that.
Okay.
I can do that administratively.
Okay.
Once, like I said, once I have everything in order. Hopefully, we can release those here in the next week or so.
Okay.
Awesome.
All right, thank you very much.
Thank you for coming in.
Thank you very much.
Thank you.
Thank you, Mr.
Thank you.
Alfonso. Okay, open space lot release, Hilltop Estates, possible votes.
Okay, we have somebody on Zoom for this. This again, kind of a cleanup item. In 2003, the planning board voted to release all 22 of the building lots that are part of this definitive subdivision. However, the planning board never officially released the 3 open space lots. So the owner of those open space lots would like to transfer those to the state, to DCR, to keep it as open space in perpetuity. But that can't be done until the board actually votes to release the lots. So I believe there's a signature page in your folder, Jake. And again, I checked with town council on this because I was wondering if the current board could act on something that was done so long ago, and our new town council said, yes, the board can, because, so again, town council has authorized this action tonight, so I will turn it over to, I believe it's Sean?
Yeah, that's me.
Okay.
Good evening, everybody. Thanks for having me, Mr. Chairman and the rest of the board. I see that you summed it up pretty well there. The only thing I would add to it is that the land is actually already protected under a conservation restriction held by the Department of Conservation and Recreation, and we are just buying the underlying fee to the property now. The protection still continues in perpetuity, and we're just looking to clean it up so that the landowner can sell to the state.
And Sean, could you just introduce yourself for the record?
Excuse me. My name is Sean Preventure, and I'm a land protection planner for the Department of Conservation and Recreation.
Okay. All right, that was one thing I was going to ask to confirm, if it was going to state DCR or town conservation.
To the state.
Okay.
And the release was drafted between one of our attorneys and town council.
Yes.
All right. Board, any questions, comments, concerns? All right, what's the wording for the motion for the vote? Just to accept
for the board to release the open space lots related to the Hilltop Estates definitive subdivision.
Okay.
So moved.
Second.
Motion made by Mr. Zwicker, second by Ms. Schlesman. Any further discussion? All those in favor?
Aye.
Unanimous, and we'll have that signed, and we'll get it to who it needs to get to.
We'll get it to you in the coming days.
That sounds great. Thank you all so much. I appreciate it.
Thank you, John.
Appreciate it.
Bye-bye now.
All right. Master Plan Committee update. Mr. Preston?
Yes. Thank you, Mr. Chairman. Let's see, we last met on Wednesday, November 19th. We're currently in the last quarter of a 2-year schedule, 6 months to go. We're in the process of writing and editing the final master plan. We reviewed the second draft of both the land use and zoning element and population and housing. The final version of all 7 elements should be completed, the definitive versions, by February, March. Our next meeting is this Wednesday, December 17th, 5 o'clock.
All right.
So, Mr. Chairman, I would request that the ADU discussion be taken in advance of the subdivision rules regs, because although that's not going to be a lengthy discussion, it's going to be a little bit longer than the items we've had so far. So Ken can come and
Come and go.
Yeah.
All right.
So the background on that, Mr. Chairman, is back in 2024, town meeting passed an ADU bylaw that replaced the current accessory apartment bylaw. However, the Attorney General rejected 3 or 4 aspects of it. Ken and I met with Jay Talaman and Brian Winter before, while they were still town council, to figure out a strategy for addressing the state's rejections, and we did that. However, I asked Ken to be here because he's been talking to me and discussing his interest and also, in addition to cleaning up what the state rejected, adding in regulations for in-law suites. So Ken can explain it much better than I can, but that's the purpose of tonight's discussion.
All right, Ken. Good to see you, Mr. Fraser.
Same here. Thank you, Board. Mr. Chair. So John and I have had discussions going forward with regards to the new ADU bylaws that were approved, but then the Attorney General had some write-ups that he wanted changed and stuff. With that being said, we've had an in-law apartment bylaw in town for many years. And we've got about, if I'm not mistaken, close to 70 in-law apartments in total that were there, and now we've only got 50-something that are viable.
Right. Yeah, about that. We have 78 on file, but 22 of those have either reverted back to single family, withdrawn, or were never constructed. So we actually have 56, I think, in total.
Okay.
So with that being said, I mean, the conception by a lot of people is that automatically an in-law apartment should be converted to an ADU. That's not necessarily true. The guidance that was put forward with ADUs is pretty strict. You're building another dwelling unit. Whether it's attached or detached, it's another dwelling unit. It's designed and uses for a rental unit. With that being said, you get all the guidelines with fire safety, egresses, utility connections, septic systems, everything that would be a new construction comes into play with that. With the in-law suite bylaws that were there, a lot of that was not in that whole setup. So they both still had the 900 square feet. The guidance with the ADUs is 900 square feet. That includes any occupiable space. So if you put a full basement underneath an ADU, that, whether you're finishing or not, that's part of that ADU 900 square feet. So in theory, you can only have a 450 square foot ADU if you had a full basement under. That wasn't, 900 square feet was never defined like that in the in-law apartments. It was 900 square feet. They just considered it, what are you going to have it and have it? So even if it had a full basement under it, they were looking at the floor space that you was going to inhabit. That being said, there's a majority of the in-law apartments, suites, whatever you want to call them, that are not compliant with the new ADU bylaws. And given in point, we have one on U Street that the ADU is 1,300 and something square feet for the one floor. It's got a full basement underneath it. So in reality, it's a 2,700 square foot home with a 14 by 40 garage. To say that that's an ADU automatically, that's a whole complete dwelling unit. That's another single family residential. But with the guidance as it is, they can come in and argue that it should be an ADU. Again, that's up to the board to decide whether they're going to allow it or not. From my point of view, it's got to be all compliance for building codes, building safeties, and all that. In lieu of just randomly saying all in-law suites in town, or going forward, I've had many people that have come in and said, listen, I really don't want the ADU. That's not what I'm looking for. I'm just looking to add space for my parents to live with us. And I don't want to go through all the ADU, guidance as far as having to do a Title V, having improved water, having to have a separate address, on and on it goes. I just want to have an extension of living space for my family. And I want to keep it that way. With the ADU, we don't have that. So my thought is, even though town meeting, the in-law suite apartment was disbanded and the ADU was put in place, it shouldn't have been. Given the guidance of the two, they're apples and oranges. They're not the same thing. If somebody has a pre-existing in-law suite and they come up and say, listen, I want to make that an ADU, well, then it would be subject to inspections in all aspects to make sure compliance for all your safety features, and you have to go through your Title Vs and your water and all that stuff and addressing and everything else to make sure that it would be in the guides of the ADU bylaws. People don't necessarily want to do that. So we don't have anything left now. It's either an ADU or it's basically nothing. So to eliminate the in-law suite, I don't think that would be a very smart move. We don't need to alter it from what it was in the original zoning or planning zoning guides, but I think it should be a viable option for people in town to be able to do either or. And I don't think it would be that confusing to explain the difference between the two of them.
Did the old regulations mention suite versus?
I think they called it out in the regulation as in-law apartment.
Okay.
It's accessory apartments. Our section is accessory apartments. Yeah.
Through the chair.
But that encompassed suites.
Yeah, they're all accessory apartments.
Yeah.
It's all under one blanket.
Ken, is the in-law apartment, I'm assuming, is typically part of the existing dwelling?
Yes.
So it's attached. If that was an ADU, it would then require all of the safety code that goes with rentals, right? There would have to be a firewall between the two units and...
You have to have 2 egresses, you have to have proper egresses,
So
bedroom.
I think that's another reason why it makes that almost impossible. You can't rent out. I mean, the old days, people used to rent a room in their house. That's all off the, you don't see that. But this is official. And you just can't, I mean, you could, I suppose, if you wanted to, go in and convert all that. Plus, a lot of those in-law apartments cover the existing basement that was there, and even though they might be 750 square feet by the new ADU regulations, you have to count the cellar.
Right.
And that also makes them non-compliant to that. So I think there's a really good reason for us to at least deal with the ones that we have already, and then if, we can come up with something with the wording that's legal for the state, then continue on like that.
Well, I don't believe that with the ADU bylaw or law enacted by the state, that it would cancel out accessory apartments. You can still have accessory apartments. It was just that in '24, when it was pushed out that you had to have answers by February 5th of 25, the law was going to be enacted, and everybody was supposed to, it was a hurried, in my opinion, it was a hurried bylaw that got pushed through without really thinking through everything, and we didn't even have all of the guidance with the ADUs locked in with the state. They came back through and they've changed many things on it. Yep. One thing was when it first came out, the ADU had to be within 50 feet of the existing dwelling. That's gone. It doesn't have to be now. Right.
Another thing was the multiple ADUs. When that first came out in that fall a year ago, they were pushing for multiple ADUs. Oh, but you can require a special permit. Well, they months later backed off on that. Right. Said towns don't have to accept multiple ADUs on the same lot. That's another thing they backed off on.
So I find that most of the in-law apartments, suites, I call them suites and apartments, to me it's the same thing. Yeah. Are just an extension of the living space for the families. So they have a door that goes from the suite into the house. I know personally when I was building, I did one that had a 5-foot set of bifolds that went into the house. And they have one door that goes out. Code requires 2 egresses. You can't exit from the bedroom through another room to get out. Okay, so you couldn't go from this bedroom through the main house to get out. Okay? And then fire separation, like you spoke of, you're going to do that all the way through, from the peak of the roof all the way down through. Now it also brings into play, if you have a 2-family house, you're supposed to have 3 meters, unless the landlord's paying all the utilities. You're supposed to have a meter for each apartment and the landlord meter, exterior lighting, accessory lighting, and all that. So now they're looking at potentially having to upgrade their whole electrical system. They're doing their fire separation. Now if there's a common area, we'll say there is a hallway between the 2 units, there's going to be a fire detector in there, and each of the units have to have their smoke and fires. At which point, if you're converting from a single family to a 2-family, you could be subject to having to do that throughout the entire dwelling, not just the apartment. So the costs keep adding up that people don't really pay attention to.
So, through the chair, let me throw something out here, see if I'm right or wrong. So, I'm just going to use round numbers. You're on a 1,000-foot house, but I want, say, my dad to come live with us. I come to you and say, I'm going to put an addition on my house. I'll update my septic system for another bedroom. I'm going to have a living room, do whatever. Tie it all in. Put an addition in the house. I don't even have to tell you somebody's moving in. If I want to put a bedroom, a living room, and stuff on my house, I can do it. If I want to have somebody move in there, I can do it. I don't need permission to have somebody come live in my house if I have the room for them. So why do we have to go through this whole process? It's nothing more than a building permit. I'm putting an addition on my home. There's nobody's business who lives in there.
Yeah, it's the kitchen, isn't
You can't
it?
have a kitchen.
Huh?
You won't be able
kitchen.
to have a kitchen.
That would be the only thing.
Yeah.
But there again, people can have a kitchen outside in the pool area. Is there, right? That ain't nobody, that's done every day. I can have a small kitchen outside behind my house.
So Mike, in other words, I think you're saying there are ways around it.
Right, so that's why have to have a full process
I think it's because
for this entity?
if
Would-
you-
Would that scenario be different from an ADU? Say Mrs. Wicker comes in and just wants to,
So just to go back, I find that most people want to be legal about it. They don't want to have to go additional. So they'll actually come in to me and say, what are the guidelines for having, I want to have my parents live with us. What do you want to do? Well, they want to be self-sufficient, but to be able to live with us. So that becomes an apartment, okay?
for them to be self-sufficient,
Kitchen, bathroom, bedroom,
Yeah.
living room.
If you're paying rent, I think, isn't it an apartment, you need to be paying a fee?
No, But this isn't an apartment, it's an in-law suite. It's a continuation of the family living. And there's one of the biggest differences. An ADU is an apartment. It is designated to be able to be a rentable dwelling. To the general public, they were supposed to be under the guise of being affordable rents. I don't know that a one-bedroom for $2,000 a month is very affordable, but that's what it was all about. So that's the big difference. And yes, they are paying rent.
Yes,
okay?
on an
And yes, they
ADU,
have their
yes.
separate utilities and everything else because they are another
That is.
dwelling. This, as an in-law suite, is not another dwelling. It's an extension of the living space. Now, I've had people come up to me and say, listen, I don't want to put a kitchen in, I just want to have a living room and a bedroom and a bathroom. Is that an in-law suite? No. It's attached, does it have that door to go out there? Maybe they have a deck off the back side of it. Is it an in-law apartment? No.
so someone
It's an
can
addition.
come in and do that addition. and-
Right, but
But if you're fully self-sufficient,
Yeah.
now you're in an in-law apartment. Because you can close off the main house and live there. You don't need to go into the main house.
So through the chair, so I'll throw this at you. In my basement, I want to have a kitchen because I do, say, steamers and seafood and stuff like that. So I have an oven, I have a dishwasher, and I have a sink. What, I can't do that? What, it's my own house. If I want to have an extra stove and a fridge in my house, I can have it.
Can I just bring this up from our files from that standpoint? Of the 56 accessory apartments that we have on file, I really have no idea how many are in-law suites at this point.
Correct.
Some of them have been coming back every 3 years for the past 20 years. I have no idea which ones are in-law suites or which ones are not. That's the question I have, is enforcement. Females who get married aren't necessarily taking their husband's names anymore. How do you enforce this? How do you make sure that these people are blood relatives? DNA test? Obviously, I'm joking, but that's a legitimate concern I have, is I have no idea how many of those 56, from a staffing point of view, are in-law suites at this point. So I don't even know if it's possible to know what we have. And out of the 56, there are a total of 6 that are above the 900 square feet.
I remember most of those, yeah.
There are 6 of them, so that's a very low percentage. So that's one of my concerns, is we don't know which ones are actually in-law suites, and how do we find that out at this point in time?
Are they, here's a question, are they signing the application declaring a relative under pains and penalties of perjury?
I'd have to go back and look at the application.
So,
That was part of the application.
because then that's on them, at the end of the day, it's the liability on them if they're violating or going above and beyond, because it's the insurance. if there's an issue.
But where everything's
But-
accessory apartments, not all of them are in-law
Yeah.
suites.
But to go back to the question I just had, there's nothing to prevent me from having a second kitchen in my house. If I want to have another stove, a fridge, and sink.
Well, I can't say undeniably that there isn't anything in the code that dictates what would be classified as a separate living quarter as far as an in-law apartment setup. But in the building world, in the real building world, if you was to do that, that would be considered an apartment. So is there anything legally in the code book? I cannot sit here and say yes on.
Okay.
All right? It's the same thing with what clarifies or justifies a bedroom.
Right.
Right? So there's many things out there. Well, if you have a closet, it's a bedroom. Well, if you have a door that closes, it's a bedroom. Well, if you have an egress window, it's a bedroom. What justifies being a bedroom? Because of a label on a print says it's a bedroom or an office?
Make a living room a bedroom. You'd make a living room a bedroom.
But I mean, in the building world, what is saying that this is a bedroom? What is actually on the, I'm looking at a drawing, and somebody came in with a 3-bedroom, and I've had this happen, a 3-bedroom design, and they have a 2-bedroom septic. So they take the pen, study, or office. Is that justifiable? I don't know. In the code, they give us square footage required for a bedroom, ceiling heights required for a bedroom, but they don't give a, if you have this, you can say it's a bedroom. So I go to the ads, because this is how I was shown and taught. If it has a door that could be offering privacy to a room, and the room dimensions meet the requirements for a bedroom with an egress window, it's a bedroom. If you don't want it to be a bedroom, put an arched opening in it. Take the door away. Now, I mean, nothing's tried and true in this industry. We got, I got 40 books of codes, and you can go through all 40 books, and you'll get 10 different answers.
40 different answers.
And none of the answers work for each other.
So Ken, do you have specific language you're looking to add, or a certain section specifically?
I'm thinking almost keeping exactly what was in before and adding this ADU law for people who want to do an ADU. I don't know why the in-law apartment was eliminated. I can't see any justifiable reasoning for that to have been eliminated to begin with. I think it was just a very hurried up documentation that was written and thrown before the board to get under that February 5th guideline for having something in your books. I don't think that the time and caution was taken that should have been. Again, that's my opinion. Personally, I don't think the in-law apartment should have been eliminated.
John,
the ADU should have been added.
Thoughts and guidance on what we could potentially do?
In terms of it's the board's decision as far as whether or not to reinsert this language. And I've talked to Ken about this. My concerns are this. We originally had accessory apartments. That's how it was referred. Now, going forward to this town meeting, we passed something a year ago, and yes, it may have been rushed. I'm not going to disagree with that. I'm not going to agree with that because I wasn't here. But that's what was passed at town meeting. Now we need to go back and fix what the state rejected on that one and add something in that was deleted previously. So to me, that's going to be massively confusing to town meeting to do both those at the same time. And the terminology, that even though we could sit here and say it's the same thing, to the general public, it was accessory apartments, now it's ADUs, now it's in-law suites. So I think I've expressed my opinion that if the board decides to go forward with this at the May town meeting, I would recommend 2 different warrant articles, because I think to put them both in one are 2 different, I think it's apples and oranges. Yeah. And I think cleaning up what was already passed is much different than saying, oh, wait a second, we deleted something in error, we need to add this back in. So to me, it's going to be a clunky process, but if the board decides to go forward with doing that, if you guys feel it's important, obviously Ken and I will come up with the language to do that. But I think that's the easiest way going forward, having dealt with town meeting a lot and knowing that confusing usually means it gets voted down if you try and cram too much in. I think that's the easiest route forward, because I also wouldn't want to see it be an all or nothing article with both either pass or both either fail.
Yes.
Because we have to get something on the books that was, we already passed something, we need to get this into the bylaws corrected from the state. Now adding something back in, it may be received very well, but I think it needs to be its own thing.
Yeah, it has. If we don't keep it separate, then if it gets rejected again by the state.
Now we're back at square one.
Yeah.
We're back at square one.
Yeah.
So I wouldn't recommend changing anything that was in the original bylaw for accessory apartments. We still call them accessory apartments. It just gives that ability, it's a distinguishable ability between an accessory apartment and an ADU. I don't think I would, I
So
mean,
you
without
wouldn't change it to in-law suites?
no,
Okay.
just keep it accessory apartment.
That would
But
make things a little bit easier.
We could go through and review what was in the original accessory apartment guidelines, but then you have your ADU. So you definitely keep them separate, but it gives that ability for people to say, what is the difference here? And there's quite a bit of difference.
So my thoughts are, take care of the ADU issue. Hold on to this language for the accessory apartment, go through it, take out anything that's intermingling with potentially ADU versus not ADU. Stick to just language in that as accessory apartment or accessory suite and get that in the bylaw separately. So then we have a ADU bylaw and then an accessory apartment bylaw.
Right.
That's what I think.
Yeah, I wouldn't want to see them together.
Yeah.
They need to be two separate ones. I mean, we have it in many different aspects of the zoning and the planning boards of variations of things, but it could be, I don't think it would be cumbersome to do it. I think people, once they read through this and said, I'm thinking of my parents moving in. And they read through this and they read through that. Well, I don't want to go through that to have my parents move in. People coming in and they say, hey, I want to make some money. I want to do an ADU, and they read through that and they read through that, and they're going to go for the ADU because they can do that.
Yeah. And then it'd be good for you if when people come in the office, they say, this is what I'm looking to do. All right, here's the path that you want to take. Read this versus read through this and pick and choose what you want to do.
I mean, I can take and have a handout, they come into me and ask me, I want my parents to live with me, and I can give them both handouts. And say, review these, come back to me, we'll go over it.
Yeah.
So that's the thing. So I'm sorry, Ken. I didn't mean to interrupt. So what I'm looking for the board tonight is just guidance for Ken and myself. If the planning board supports reinstating the accessory apartment bylaw in whole or in essence, and obviously cleaning up the ADUs is the first thing we need to do. But if the planning board supports reinstating accessory apartments in the bylaws, Ken and I can absolutely work on that. But we're kind of coming up. It's January. May's going to come quickly, so we need some guidance as far as
Because the ADU that went to town meeting that got voted and approved this is the language, and
it replaced that. And I don't disagree with Ken. When I first started, this is one of the first things Ken talked to me about.
Yeah.
And what we did in Rutland, luckily through guidance from KP Law, is we utilized the same strategy that developers use when they hear a zoning bylaw amendments coming down the pike that may affect their property. They submit an application for their property, and that freezes the zoning. So whatever changes happens, they're immune to it. They go by the previous zoning. So I said, well, why can't the planning board open up a public hearing on this prior to that February 2nd deadline and keep the public hearing open for 5 or 6 months? Because you can. Going into a town meeting, that stops the clock. And KP Law said, yeah, you can do that. So that's one strategy we did, so we could kind of take our time and not rush it to fall town meeting. But be that as it may, I think it was hastily done. I don't think it should have been a delete and replace. I wouldn't have done it that way if I had been here at the time.
Yeah.
At the time that this went down, we had to do it.
Yeah.
I think there was only 2 months, maybe 3 months.
Yeah.
We were told we need to have it, and we did it, because everybody was afraid everything was going to be amended.
And that really was
and the
not
state was just going to come in.
Because that's the first time I've seen the state do that. Normally, when they come forward with something, whether it's adult entertainment, medical marijuana, MBTA community housing, they tell a town, okay, you need to pick an area where this is going to go, and we're going to give you 18 months. In other words, they give you a couple town meetings to do this. This is the first time I've seen the state say, no, this is going to be allowed everywhere, and they're barely giving you a town meeting to do it. So
I believe it came out the first part of October.
Exactly.
To be
And they didn't.
Again, to the chair, it's no different than anything like the stormwater that we're going through. where it's coming out, and that's why a lot of these towns got in trouble with, they just made it town-wide because they didn't know what to do. And this was the same case, but we had enough time to figure something out.
Right, so, and having it as its own article will give a chance, like, you know, I told Ken, I said, Ken, I'm going to need you to explain this, because he can explain it through the building code standpoint, and that's really what this is about, is what people have to do and how less arduous it is to do an accessory apartment versus an ADU. So I'm really going to need him to explain this when we have a public hearing and things like that, and I think, you know, obviously he did an excellent job, and so it's going to be important that it get explained well, because we are asking people to go back and say, oh, by the way, you know, so it's just a matter of educating people and just making them aware.
Yeah, and I think we can explain it at a town meeting where, look, this came rushed through the state, we had to act on it. The state's backed off, we were able to do some digging and looking into it and realize that this is the best for us. And,
it's the best for the residents.
you know,
To be honest, I don't even know that if we don't do something like this, if the existing in-law apartments would still stay legal.
They would be probably pre-existing non-conforming in some manner.
Yeah, but that's probably only if they maintain that 3-year review. Because if you don't maintain a review,
right, then
taking that dilemma upon yourself. I don't know, I'd have to check with council, but you know.
Well, that's the other thing for this board to consider. I've heard some sentiment, talking to, you know, members of the board, I've heard some sentiment for a desire to not continue with that 3-year review.
I concur with that.
Because it becomes arduous, and that's another thing to consider, and I know, Ken, you've expressed that you would like to see that remain under this as well. That's the other thing at play.
I'd even want to see like 5 years, because 3 years, not a lot changes in 3. 5.
I think the average time somebody, Meg might be able to answer this better, the average time somebody stays in their home is 5 years, they move on to the next one.
5 to 7.
Yep.
Yeah.
If I can, though, through the chair, the thing is, though, you make an ADU unit not do that at all.
That's under state guidance.
I'm just saying, just hear me out here. So you're going to have one person with an ADU in this lot, and I'm in this lot. He doesn't have to do nothing, but every couple of years, have to come back in front of the town and everything else.
So that person has a building permit, they're taking in rent.
Right.
It's a whole different ballgame versus a little addition for a family.
But I understand what Mike's trying to say, so, you know.
You want to keep it fair.
So hold on, so part of the purpose of this is to make it less arduous for the people who want relatives living there. But if coming back every 3 years and recertifying, I think that's what Mike's trying to say. Is we're telling them we're making it easy on one hand, but on the other hand, we're not making it easier. We're making them do something that the other people
But it's less expensive because they don't have to meet all the requirements of a rental unit.
Right.
So it's beneficial.
I mean, in all honesty, I've probably been to at least 12 meetings about ADUs. The state still hasn't even determined, this is how still up in the air all this is. If you have a duplex, are you entitled to put an ADU on your side of the duplex? Now, because you're an attached dwelling in a duplex and you put an ADU, does that become a 3-family subject to sprinkling the entire building? That's the answer you get.
Yeah,
So
a lot of questions were met with crickets during those seminars that I went to last fall as well. Not a lot. It's so funny when you go to the webinars and you see all the people, like, just comments, and the state had no answers to any of it. People were so frustrated. So yeah, it was a very rushed process from the state, very forced down the town's throats. And so yeah, the town had to make a decision with very imperfect initial information.
I don't know how many court cases there are now with regards to it, but I know that a lot of the comments I got back from people from the state from doing the seminars, well, you know, if that's how you feel, you should bring that forward in a suit or a case against the state. And it's like, okay, so what am I going to be, about 5 or 6 years out?
Yeah, who's going to do that? Who's going to take on the state?
So, I mean, I always look at simplifying to the point where it's easy for, I want the contractor, I want the homeowner to be able to go in and do anything they need to do with regards to building and be able to get an answer that's straightforward and upfront. I want them to be able to fill a permit out online and not sit there saying, oh my God, it was like, going and getting my head drilled, So to simplify, putting that back in, it just simplifies the process for somebody who just wants their in-laws living with them.
I think what Ken proposed makes perfect sense. I only wish we saw it sooner. As you're saying, I was like, why didn't we see this? It's two different animals.
It was very
And I think it would be well received by the community because it gives them two options. One is just additional living space. The other is a de facto autonomous apartment. Even it might be considered a small house, if you will.
I think the reason why is because when we were looking at all of it, I don't think we realized that the ADU changes were really slated for rental units.
Right.
We weren't thinking that. We were thinking it was just replacing.
I don't think the state was even considering in-laws when they did
The
this.
in-laws, the ADUs, and I'll go on a record saying this, and I've said it to the state many times, they were designed for the Cape and Islands, for people to increase their income in the summer months. To the point where this past town meeting in Nantucket, I believe it was on the town meeting to ban off-season rental on the island. And their concerns were being able to supply the island for the workers, for the people there, and everything else. It did pass, or it did not pass, because the majority of people who own property on the island don't live there, but they have the right to vote, they showed up. So it didn't pass, but they were trying to get that through.
I think it presented at town meeting and presented well. I think they would come to appreciate, we're just giving you options here.
Yeah.
And I think it would make your job a lot easier, too. frankly.
Yeah, so I think we move forward with the ADU, separate it, come up with an
And then Ken and I
accessory.
work on the language for the accessory apartments, whether it's exactly what's in the bylaws already or tweaked a little bit.
Yeah, because I think there'll probably be some stuff that references what would be covered under the ADU, potentially.
Yeah, I'm sure there's overlap.
Now, would we want, am I thinking here now that there is ADUs, do we want to maybe eliminate detached accessory apartments?
Eliminate what?
Because ADUs can be detached, you have to allow detached ADUs.
Yeah, do we want to allow detached?
Because you want them to be in-law suites.
Apartments?
Yeah, that may
It
be
could be,
something we correct.
that could be the language that an in-law suite attached to the existing dwelling.
Yeah.
I was going to ask the same question. I
Yeah, if
think
you want to detach
they need to be
a separate
attached.
thing, you fall under the ADU.
So I just want to be sure going forward that we all use consistent terminology, because I'm hearing in-law suite, accessory apartment. I just don't want people to be confused. It's accessory apartments. We're going back to accessory apartments. So, because if we introduce a new term, I think that inadvertently throws a wrench in the works where people are going to get confused. So I just
But we
want
can-
everyone to use the same term, accessory apartments.
we can define an accessory apartment
Correct.
as an attachment or build-out of the existing.
And that's where we may want to tweak it to cater it to be in-law suites.
Exactly.
Yeah.
But we're not using the word in-law suite, we're saying
Yeah,
accessory apartment.
right.
Okay.
It's not an ADU.
The only twofold, if I don't mind, going over it on the review, keep the fees fair, if there's going to be a fee. I know there's been fees in the past for the 3-year renewal and all that kind of
I
stuff.
think it's $50 every 3 years.
I'm not sure what it is, but on that aspect of it. And then on the separation of the accessory apartments and the ADUs is, remember, we have people that have a garage or whatever offset from their house. They want to make it for a family member. Now, what happens when that comes into play? Is it all of a sudden?
I mean, we just approved one a few months ago.
Well, that's what I'm getting at.
But I mean, I
we
would
just said that you're going to attach it all.
Wasn't it attached?
But there are some
No,
that
it's
are
all garage.
unattached.
So
But it was
I
attached.
So,
lean towards
no.
what he,
The garage
No,
wasn't?
it wasn't.
I thought
Gross said
was that
attached
long one, right?
dwelling,
They had the wrong
extension of a
dimensions?
dwelling. If you have a garage you want to have as an in-law, it's going to have to fall under the guide to the ADU.
Because there is guidelines for it.
Yeah.
It's under the ADU.
I'm just saying, just so that there's clarification in whatever print we have. Whereas, and we've had more than one
Yeah.
where the accessory apartment is a separate entity of the house.
Yeah, you can still do it for your family, but then it also gives you the option that when the family moves on, you can have it as a rental.
So no
Well,
matter
that's-
what's going to be necessary, if, if we go forward with this and this passes at the May town meeting, is we've been holding off on having people come forward and renew on the accessory apartments pending what happens with this.
Right.
So we're going to have, I'm going to have to contact people saying, okay, now you have to come in and you need to renew because it expired. So I do have a spreadsheet that shows all the expiration dates, but so we're not going to have people come back until this is settled and we hear from the agent's
Yes.
office. So later next year, about a year from now, you're going to see people coming back into the board to renew.
And to possibly extend the term,
Yeah.
Yeah.
And reduce the fee or whatever.
make it a 5-year.
But I mean, the guidance also can say, we're not telling you if you have an in-law that you cannot take and convert to an ADU, but you're going to have to follow these guides.
Right.
That's all with fire separations and all, everything to do with the ADU bylaw. So if you want to do that, here's the ADU bylaws, this is what you got to follow to convert, because you still have to go in front of the planning board to get approval for an ADU.
No.
No.
Yeah, that's a
ADU.
requirement.
They change it?
It's
Talk by
always
right.
been, no, it's by right, but it's still by approval. It's got to go through the planning board for approval.
No. The ADU is by
No,
right.
not
They
by
go straight
right.
to the building department.
It's by right, look at the
Yeah.
law on it, it's by right, but it's still subject to planning board review, you cannot add anything more arguments to it than
No,
building a residential home.
what was passed at town meeting was it doesn't have to come back
By right.
before the
Well,
planning board.
I'm just saying what the ADU bylaw that came from the state says, read it again, it does say
No, what
that.
they said is they want it by right, but towns can have them come before the planning board for site plan review, but that's not what was passed at town meeting here in Douglas. If it's by right, it's not site plan review. It's by right straight to the building department.
I haven't read it.
We did it through site plan review in Rutland, but you don't have to. The state was pushing by right. And when I talked to town council, they said, well, the most you could do is by site plan review, but the state really wants it to be by right. They were really pushing by right.
I thought we were by right.
We were
site
by
plan
right.
review.
It is.
I thought we were,
Yeah.
The only way it was going to be in front of the planning board was if you wanted more than one. Then it fell under.
I don't even know if it's that. I think it restricts it to one per lot.
yeah, let's research that, just to make sure everyone's on the same
I think it's one per lot,
page.
and it's straight to the building department.
More than one special permit.
Did one per lot come from
What's
the
that?
state?
No, that's not in the bylaw that was passed by town meeting. It's restricted to one per
Per
lot.
lot, okay. 'Cause I know there was a big issue.
The guidance came out for an ADU, you're allowed by right one per lot.
Right,
Right.
right.
By special permit, you can add on if the town so desires.
Yep.
So the one that was passed here, I believe, is one per lot, and it doesn't have to come before the planning board for accessory dwellings. So, all right, so I would like a vote from the board after this discussion to authorize Ken and myself, because obviously I'm going to work on the bylaw to correct what the state rejected. We have to do that. But also for Ken and I to work on reinserting accessory apartment regulations as well for town meeting in May.
Yeah, so not reinsert it, because we've already replaced it, but take the language and form a new
bylaw, correct?
Yeah.
Yeah. A lot of it will stay, but a lot of it will have to be changed.
Yeah.
There'll be a lot of period things.
There'll be some changes.
It's going to be streamlined.
Amended,
Yeah.
yeah, to
Do a
amend it
review
out.
between the two of them,
Yeah.
go back and forth to
So
see.
that way nobody comes in and argues and said no.
And anything that's changed,
Yeah.
if it could, like you've had in the past, in red, what we're
Yes.
changing between the two.
Well, and that's
That
another
was there.
reason, I wanted the two articles, because if we try to do both at the same time, there's going to be red all over the
Yeah, no,
place.
I agree.
Red, then green, then
Yeah.
back to red, yeah.
Yeah.
And then black.
Arrows and-
So it will make it very simple, because whatever Ken and I work on, there's going to be no red lines, because we're simply putting back in something that's based on this.
Yeah.
Because technically, this has already been
It doesn't exist.
taken out
Yeah.
by town meeting. So technically, this section doesn't exist anymore.
I know what you're saying, but
just wants to-
we
what was originally-
have a reference point, is what I'm saying.
no, we do.
What we had before is going to be used as a reference point for this board. So anything that is amended or changed from that original bylaw, if it could be in red, that way they would know what is being amended from that original bylaw.
Yeah, just we know, like, all right, yeah, that's going to be under the ADU instead, or it doesn't need to be there. And
Correct. Or
Eliminate or ADU.
we're going from 3 years to 5 years. This said 3 years, it's in red. No, we're going to go to 5 years.
Yeah.
Or we're going to do this. Or
It shouldn't be too much.
There has to be a clear distinction between the two.
Yeah.
Also in the language.
All right, so I'll entertain a motion for John to work on the changes from the state for the ADU, as well as work with Ken for adapting a new accessory apartment bylaw with, off the previous guidelines.
And then make it 2 separate articles
2 separate.
if it goes to,
Well, that.
I'm just saying, so that to 2 separate entities.
So moved.
So moved.
Made by Mr. DeRose, second by Mr. Zwicker. Any further discussion? All those in favor?
Aye.
Thank you, Ken.
No problem.
Awesome.
That works.
Fun, guys.
Thanks.
Mr. Chair, a couple of somewhat relevant comments to ADU stuff from one of the seminars that I attended. It'll take just...
I'm just trying to think what we can do it under.
We can do it under open session for topics not reasonably
Yeah.
anticipated.
Okay.
didn't really fit with
Yeah.
that, so...
All right, subdivision rules and regulations amendment discussion.
So, the directions I had coming out of our last discussion were A, insert regulations specifications rather, for asphalt sidewalks, after our discussion with Adam. So that's what you see in here under section 6.4. And on the second page, I'm sorry it's not highlighted, but the asphalt sidewalk specifications. So what I did, and Adam has read through this, I sent it to him and he's approved this, is I kind of organized it. I put general specifications that apply to both asphalt and concrete in that first section. Number 1, 2, 3, and 4 that are highlighted in red and purple are basically regulations that are already in there, specifications that are already in there that apply to both. For instance, 5-foot wide sidewalks. They're both, that's the same for both. Then the following, then the number 1 and 2 on page 30 are specifications that I was sent by Adam. These are directly from him, number 1 and 2,
Page 30.
for asphalt sidewalk specifications. Then everything else after that is exactly what was in the subdivision rules or regs. We already had it in there for concrete sidewalks. And then at the end of that section, you can see the 4 items that were deleted and moved up to the beginning. I thought that organized the section better. General, and then asphalt, and then concrete.
My question is under sidewalks 6.4, number 2. What is the detectable worn-in panels cast in place?
I believe,
Those are the temple.
yes,
Temple
for
floor.
handicap, that's for ADA.
Yeah, for-
Those are cast iron? I thought those are plastic.
Covered in plastic.
coated.
Yeah.
That's a good question. I don't know.
I've seen
That would be
them.
a Ken question.
Yeah, I've seen them
was that
installed all the time. I thought those were plastic.
That could be something else then.
But does it specifically have to be?
Tactical warning panels.
Maybe this is talking about separate from the curb ramp, because the ones that are plastic, I know they're plastic.
Yeah.
They're fiberglass or something.
Yeah.
That forms the whole curb ramp.
Right, that's for walking canes.
Yeah, but it's the whole ramp. Maybe they're talking about something when you have a ramp, you put in a cast iron thing in front of, before.
Do you know where that came from, John?
No, that was,
language?
I don't know, that was already in there.
Okay.
That-
'Cause,
I didn't change that.
I'm confused on what exactly it is.
Yeah.
And if it does need to be there, if
Right,
it
let me
exactly has to be manufactured by one certain company,
Or
I don't
what
know.
is it?
just in case that company goes out or there is another company that makes them.
Yep. Let me check on that with Adam.
Okay. Yeah, I'm just curious what exactly that is and if it has to be specific to, it has to be by
Yeah.
one manufacturer.
You're not speaking my language in that one, I have no idea.
Yep.
So the rest, like I said, Adam's taken a look at it. He's
The curbing, curbing
Where are you, Mike?
on the sidewalks, anywhere. We doing asphalt, Portland, under the sidewalks. We have nothing for the curbing. Because the sidewalks are gonna be meeting or butted to the curbing.
Yeah, because we eliminated the grass strip.
Right, so we need to know what kind of curb your sidewalk's gonna be up against.
I don't know, I don't know.
Well, with discussions from in the past, I know
Was that in 6.5 before?
Oh, well, it says, yeah, dense graded sub-base compacted and sloped toward the curb at a rate, blah, 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 blah.
but they're not giving a curb.
Oh, I thought we had that.
Because I know on the concrete sidewalks, we are talking about having the concrete curb as one
Or
shot.
granite, yeah.
Hold on, section 6.2 already has curbs and berms.
Okay.
Oh, it
Part of the
does?
section.
Well, that's why we're
Okay.
not seeing it.
That's why we're not seeing it. I just gave you copies of it.
Yeah.
We've already discussed other aspects. I just
Okay.
want to narrow it down to
Yep.
these two things. We already have curbs and berms in section 6.2.
Is both for asphalt and concrete, right?
Yeah, it says Cape Cod bituminous concrete berms shall be required throughout the development, blah, 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 blah.
Yeah.
And then it talks about granite curb specs too, so.
Right, but if there's a concrete, if there was a concrete sidewalk, the curbing in the road was going to be a concrete curb.
I don't know, that's news to me. That wasn't.
I have pictures of it from Adam and stuff. So I'm just saying, that's why I'm bringing it up.
Let's ask.
But that's something that we can look at and add in.
Well,
So,
what,
Mike-
what are you confused about? Or what's the debate? Because we agreed to go forward with
Type the curbing.
granite, asphalt curb, Cape Cod, and asphalt sidewalks, but in certain areas, like a main street, whatever, that's what the concrete
Well, in
sidewalks
instances
would be.
where planning board so requires, curbs and berms shall be installed in accordance with the following minimum requirements. So we don't have language that says, if you do this, you have to do that. So right now, we have concrete sidewalks as an option in our current zoning bylaws, and this is the wording we have for curbing. So do we want to start getting into that level of specifics?
That's from Mr. Corno.
Yeah.
See the
I mean,
concrete?
I get that, but I'm talking about the language that goes in here.
No, I just wanted to.
Yeah. So,
Well, we're not going to ignore it because this was discussed and brought up on the concrete. For the, if there's a concrete sidewalk, the type of curbing that was going to be used.
but that's up to the planning board. These are just specifications.
Is that just 45 feet and the whole, you know what I mean, cut in?
That's what Adam,
Curb line?
he sent me those pictures.
Well, I'm just wondering if that's a 5 foot to the curb, and you cut that curb line in with a flow, you know what I mean? So they pour it out, you know?
That's why we're having a discussion.
No, that's all.
So I'm just trying to catch up with you, Mike. We have in here, it says, specs for Portland cement concrete sidewalks.
Correct.
So what's your concern?
If you're using the concrete sidewalk, you're going to be using the concrete curbing like Adam wanted. Or you're going to have asphalt curbing and then a concrete sidewalk abutting to it. That's what I'm bringing up. So what was brought up was this. He sent me this picture where the concrete is all one pour, part of it's your curb, the rest of it's your sidewalk. That's right from Adam. Right there,
I
there's
think
emails.
in this case, depending on the project, we see what they're proposing, and we ask Adam for a comment to make sure he's okay with the types of curbing and sidewalk that's being
Right.
proposed.
Let me ask.
But you're putting one spec in there, you put them both in like the sidewalk, then you decide between the two when they come in, which way it's gonna be.
I'm not putting anything in. This is coming from Adam, so.
I mean, would it be out of the question, sort of a rhetorical question, and I know I lost this argument with the tar. Can we have specs for both?
That's what I'm getting at.
Can we put them both in and say, if you want to put concrete in, we think it's a better product, longer lasting, can we put in specs for both, so at least it's in the bylaw, it's in the rules and regulations?
Yeah, we do have specs for both, asphalt sidewalk specs.
But are we leaving those in?
specs.
Are we leaving the concrete specs in?
Yes.
I thought we were gonna
Yes.
pull those.
Yeah.
No, because Adam said there are areas like in the downtown
He wants the
where
concrete.
concrete curbing,
Okay, but-
concrete sidewalks is appropriate.
But there wouldn't be opposition if a developer, I know it's going to be a real thing, but if they say, I really want concrete sidewalk,
Correct,
Yeah.
They could.
they can,
correct.
yes.
No, and I'm 100% with you. I'm going to the page before. When it talks to the curbing, they should both be in there too.
Okay.
The asphalt and the concrete. If you have a concrete sidewalk, you have a concrete curb. If you have an asphalt sidewalk, you have an asphalt curb.
I think,
It's not in,
But you can have asphalt sidewalks with granite curbing. I've
I
seen.
didn't say granite. I know.
No, you said if you have asphalt, you have to have asphalt curb, but you don't have to.
No, you don't, but for the whole, you use the granite curbing at your intersections in those major joints, not 2 miles going down the main road.
But what if somebody wants to do that?
Then they can. But the idea is you have the option in the regs, just like you have to in the
Mike, I
sidewalk.
think under the Portland cement concrete sidewalk specs, number 1 takes care of what you're concerned with. It says, concrete shall be formed in place, placed on an approved base, properly finished and cured by experienced concrete finishers.
It's not the curb. The road curb.
I don't know, I just don't think we want to paint ourselves in a corner to say, if you have this kind of sidewalk, you have to have this kind of curbing. I think there are different options, and I don't think we want to, again, we don't want to create unintended loopholes, and we don't want to paint someone in a corner.
So why don't we back up a minute, and we're not. We're doing the same thing as we are on the sidewalks. There's 2 options here, correct? You have concrete and you have asphalt for sidewalk, correct? For the sidewalk.
Yes.
In the curbing, you have your options. You have concrete,
Thought we had granite.
you have your asphalt, and then your corners, you have your granite, but you don't have it in there for the concrete, for the curbing.
Okay.
We had granite and asphalt.
That's it, but you don't have the concrete.
Okay. So you want to add a paragraph in for
And/or
concrete,
concrete.
for concrete curbing? Okay.
Correct, that's all it is.
Now I get you.
Now I get you. Took us a while to get there.
Wasn't it? It just showed the whole thing.
No, just get where you're coming, just trying to get in the right
Yeah.
place to get there.
Well, I did, that's why I had the picture. So back, I'm wondering, before you came
I
here,
didn't understand where you were going with that, Mike. I
Well,
thought
we-
you were saying, if you do this type of sidewalk, you have to do this type of
no,
curb.
but you need to have the option in the book. So the original deals with the highway department was with the concrete sidewalk. He wanted to have the concrete curbing with it. That way there's one unit, you do one pour.
Yeah, that's fine.
Take care.
And that's
Yeah,
all that
yeah,
this is
so
all
that's
about.
Debate's
Okay.
over.
That's what we tried to go through.
All right,
Okay.
anything else, John?
So yeah, just, Rich had been harping on this, so I got, and rightfully so, rightfully so.
okay.
Yeah, no. Because if you look under monuments, I had Zach Less from Existing Grade send me language to add in regarding the establishment of bounds. So it takes away the subjectivity or having it be up to the planning board, and it puts in the specifications that be precast concrete or granite 5 inches. So all those specs, that comes directly from Zach, that language. So I took it out, conform to the standard specs of the board, because the planning board doesn't have standard specs. So that was a great catch. So that language came directly from Zach.
Thank you, John.
You're welcome. I didn't need to say harping.
I actually kind of liked it,
So-
because I was.
All right, so I would like to get to the point where we can schedule a public hearing soon. That's what I'm trying to get to. So can we schedule a public hearing and make these changes that we discussed tonight, adding in specs for concrete curbs, finding out what the temperature warning pads? Do you want to have one more discussion before we do that?
My only question was that what exactly that cast iron warning thing is, so I don't know if we need to go another meeting just for that.
Okay.
But,
Through the chair, while we were talking about concrete, I looked up the website, and those panels are what I thought. They're rectangular panels that go in before the ramp. They come like 2 feet wide, 18 inches, and they got the dimples on them.
So, yeah, so
Both-
someone who's sight impaired
Yeah.
can
You can
detect
feel
where they
them.
are. Okay.
Yeah, and both companies sell the same thing.
okay.
They're just big dimple
Yellow?
panels. No, you can paint them, but they come cast
Oh,
iron.
so it is cast iron, but they paint over them. Because
you
I
want.
have seen them get rusty, so that makes sense.
Some places, I guess, like,
Yeah.
you know.
The ones I've seen that get put in all the time are just yellow. They come in a package and they're yellow and they're ready to go.
Cast iron with the antenna for the sidewalk plug goes on that plastic.
Yeah.
Fire.
Yeah.
Would it be cost prohibitive if they were stainless? I don't know.
I just don't know. if
They'll never
EDA
rust.
spec.
Yeah.
I'm sorry?
I don't know if it's EDA spec.
Yeah.
Force that, you know what I mean, or manufacturer.
But I mean, for us, so they don't
Oh,
rust.
100%.
For the community,
Yeah,
Yeah.
yeah.
maybe cost prohibitive.
Yeah, I'm very cautious changing anything
Yeah.
that deals with the ADA because it's
Yeah.
very set in stone what they want, and you can't get waivers from.
No, and it does say or approved to equal, so.
Okay. Oh, there you go. So it gives the board the option. So does that satisfy your question, Jake?
Yeah, I think so. I just did not think those are cast iron.
I always thought they were plastic.
Yeah.
So,
Plastic.
if it pleases the board, I would like to schedule a public hearing. We don't have to do it the first meeting in January. We could do it the second meeting in January. That'd give me time to get those concrete curb specs in from Adam and circulate them to make sure that we're okay with them before the public hearing. So how about if I schedule a public hearing for the second meeting in January on the
Yeah.
28th?
Because then, and that you can give us the final,
Yeah.
here's the final, all the changes.
Yes.
Here's your read.
Yep.
Does the language need to be posted prior? And if so, how much in advance?
We don't have to. We can just let them know changes are being made, and then it'll be available in the meeting
No, I
packet.
wouldn't want to make it more complicated.
So what I will do, Jake, is not necessarily have every administrative change, if that's okay, just have the substantial changes that we're making, if that's okay. Or do you want every single change we're making?
Don't hide anything, put it all out.
Yeah.
All out there? Okay.
And then in case someone comes
Put it all out there.
in too and says,
Okay.
something we didn't change, hey, you should add this, maybe?
Yeah.
Well,
So
not
it's all
that,
in there.
we don't need, there's no reason to have the community go, well, why aren't you showing us all of it?
Okay.
I mean, it's only right to you put it all out.
Okay.
And it also helps show that, we're just trying to clean it up.
We're being open
Yeah.
about the process.
All right.
This is what we're looking at. What do you think?
Okay. All right. Ongoing development, any updates, John?
Sure do. Let's see. The Cubes of Gilboa. Keep hearing from Mr. Manerick that negotiations are ongoing with 3, possibly 4 companies to occupy the building, but nothing definitive yet as far as who that will be. Witten Reservoir Estates. The engineer stated that efforts to communicate with the owner to complete the improvements necessary to have the roadway accepted have been unsuccessful. I've had conversations with Ken, and Ken's had conversations with Matt Wojcik. The town is considering the possibility of beginning the process of taking the bond to be able to complete the work ourselves to get that done for the residents there, because that's been going on for years. We're holding a bond of about $25,000, but, if we can have the DPW do certain things, we think that $25,000 is enough to, most of that money would be to prepare the documents for roadway acceptance. So,
How are the retention ponds? I know that they need a little bit.
well, that's part of it. They may need to be.
Yeah. That was the hard part on that one.
Yeah, they may need a little bit of cleaning out. That's one of the things that need to be.
Yeah, I've had enough with trying to deal with that developer, so whatever we gotta do to.
Deer Crossing, obviously, Phase 6A is under design, and the applicant has requested to continue to use Graves Engineering, so they're moving forward on the last phase of that. Douglas Package Store, it looks like the foundation is going in, so that's moving along, which is nice to see. And then, obviously, we have the lane at Hunts Pond. They're moving forward with a new owner, and they'll be actually starting activity on that here in a couple months, so that's good.
Any word on Sutton Douglas?
No.
Wow.
Not heard any word on it. I had heard that they were supposed to be starting in the spring, by the spring of 2026, but I haven't heard anything about that.
Just crickets, huh?
Yeah, just.
Because that was what, 30, I think it was 30 houses, wasn't it? Close to it?
I think it was more than that, maybe.
Yeah.
It was a decent amount. All right. Town planner report.
Yep, just, we have a public hearing scheduled for January 14th for the Freshwater Reserve, which is a flex design subdivision off of Southwest Main Street. We had a tech review meeting, and I've been receiving comments from various departments. So for that public hearing, I'll have a summary memo for the planning board summarizing all the department comments for your information, and also my own comments. This is going to be a tricky one because it's a tight site, and also they're going to be looking for a significant waiver. So yeah, it's going to be, this is good. This is not going to be, in my opinion, it's not going to be a straightforward.
And this is our first one I think we've had with you, so you already mentioned you were going to do it. I'd love to see just the comments from the peer review.
Absolutely.
The tech review, just
Yes.
so we
Yep.
have it.
Yep.
I like to actually look at it and say,
Yep.
the police chief said this, the
Yep.
fire chief said this, highway super
So
said this.
I've gotten comments so far from building, assessor, fire, and also Adam. So I'm still waiting for comments from the police chief, but we've gotten the comments from the major departments so
Yeah.
far, and I'll have my own to add to that. So
Yeah, it would just be nice to actually
Yep.
have those comments in front of us. 'Cause,
Absolutely.
we've gone to these hearings and I ask, are there comments?
No, I actually have a summary memo started.
Okay.
And so I have all the comments that I've received so far, and I'll add to them when other departments come in, so I already have that going.
All right, thank you.
Have that one in there.
It's called Freshwater?
Freshwater Preserve.
Freshwater Preserve?
Yes. So administrative update. Our senior volunteer has started. She's working on A&R files, researching which ones have been recorded, and the vast majority have. I was pleasantly surprised that there's only maybe half a dozen A&Rs that haven't been recorded, which is really good. And then the next thing she's going to do is she's going to reorganize those A&R files to be filed by alphabetical order by street rather than chronological, and make files a lot easier to find.
You said a senior...
Senior volunteer for the senior tax program.
Okay, I didn't know if it was like a senior intern?
No.
Like a high school senior or the
Yeah,
tax
they have
program?
a senior citizen, and actually she has quite a bit of experience in this type of work in Arizona with land use and things like that, so she really knows what she's doing.
Nice.
So,
It's great.
I didn't know we had that.
yeah.
I knew we had that program. I didn't know your office had someone.
Yep. And lastly, this could be a vote from the board, but I was contacted by Emily at CMRPC. Meg had asked me about the DLTA grant program. So the master plan committee has been discussing the need for recodification of our zoning bylaws, update of our zoning bylaws coming out of the master plan process in 2026. So Emily offered to include us with the town of Rutland on a grant application to do what's called a zoning bylaw diagnostic, which means they look at our zoning bylaws for inconsistencies with state law, inconsistencies with other regulations, updates that need to be done to clarify things or reword things, and then they present us with those findings and recommendations. And I think that would be a really good first step as we prepare to look at our zoning bylaws and redo them so we have areas of emphasis. So I'm asking for the planning board's blessing to go forward with including us on this grant application to start that process. And I would, if the planning board approves that tonight, I would get a letter of support from Matt as soon as tomorrow and get that going with CMRPC.
You need a vote?
Yeah, it would be great if you would.
Make a motion to request the grant money for the zoning bylaw diagnostics from CMRPC in combination with Rutland.
Second. Made by Mrs. Wicker, second by Mr. Preston. Any further discussion? All those in favor?
Aye.
Great. Thank you. That's all I have, Jim.
The signatures that are going to be going around, and Mr. DeRose for open session topics.
Yep. So just a quick update on, in October 2nd, there was a region-wide ADU seminar done by CMRPC. And there's a presentation that they handed out at the end. It's got some really good links to all the state stuff. There's a lot of different court cases and things you can look at if you want to see who was complaining about what and what the outcome was in terms of can you or can you not do certain things. But what became really clear to me in those discussions was that the real push by the state was these ADUs are low-cost housing rentals. That's what they're trying to do. And that's why the laws changed. We already discussed it as 1 unit per lot is the only thing the state law covers. Towns can agree to have 6 if you want, but we can still restrict short-term rental of ADUs. So you know that I think that is something that probably got put in for all the seasonal areas. If it's going to be rented, an existing one has to be brought up to the current fire code, which is something Adam mentioned. And the other thing is they require unique home addresses. So they have to have their own address now.
Oh, no kidding.
Yeah. Yep. This is another thing the state is really trying to promote, and this one here didn't make much sense to me as a potential person building my dream home. But the thought was, you're going to build a dream home. You know, you can't afford to do it all at once. So you get a permit and build what would be a compliant ADU. Then you live there, save your money, and then you build the other home. And then you move into the other home. Now you've got rental property in your dream home. And that doesn't make sense, because I don't want to rent out my dream home.
I don't know if that is possible, because Ken and I had a discussion the other day about the possibility that a detached ADU could be separated through an A&R process and sold separately. And when we looked it up online, it said an ADU still has to be on the same lot and have a connection to a principal dwelling. So I'm not sure that scenario could play out.
What they were saying was that you would still own it and you would rent it to somebody. So it is an ADU. But the small house that you were living in the beginning now becomes the ADU for rental. But I've got my $1.5 million house I just built, and I don't want an ADU in my backyard with people I don't know living there.
Well, yeah,
you know,
yeah.
So I don't know that that's going to work out. Most people, you know, but it's something we need to keep in mind that, you know, if you build a 900 square foot house,
So you're saying that the 900 square foot principal house that's built initially could eventually turn into an ADU?
Yeah. Yep. By right. Now you build your big house.
An ADU at first, it would eventually become an ADU.
Right.
No,
right.
Yeah, I see what you're saying.
Yeah.
Yeah.
You don't have to tear it down.
Conceivably, yeah, that could happen.
But I don't know that too many people are going to go for that. But the other thing that they were pushing on was that they're going to create these info sites for ADU plans, pre-plans that are approved by, you know, architects, and then you can bring them to your town, or modular ADUs. And they're...
Boy, it's amazing how the state never did this before, giving people such detailed guidance and help on things, huh? They're so nice. They're so generous, aren't they?
Yeah.
They just give and give and give.
Yeah. They're giving even more. For 2026, there's $5 million slated for ADU incentives. I don't know what that is. There's no discussion, you know, no definition yet. But $5 million, and In the first half of 2025, there were 500 ADUs approved. And most of them are east of 495. The real western part of the state was pretty much blank. The other thing that I thought was interesting, an HOA can allow or restrict ADUs. So an HOA can, if there's an HOA on a neighborhood that says you can't have ADUs, I guess that overrides
It has to be in the
state.
covenant, right? It has to be in the,
Yeah,
I think so, yeah.
yeah.
It would have
It
to be in the
supersedes,
docs.
the HOA covenant supersedes the ADU bylaw.
yeah.
It has to be existing. I don't know if you can do it going forward.
The way
You can't make this stuff up.
the way it reads on the website, that it says that you can do it going, it sounds like you can do it
Can
going
do it
forward.
going forward.
Yeah.
So that would mean like a private, like group?
HOA?
Yeah, how would?
What's interesting, though, is when you have an HOA, the town doesn't enforce an HOA. The town has no right to enforce an HOA.
But then, I guess, how do you enforce, I live in the HOA, I know that I'm not supposed to have an ADU, but I'm going to go apply for one anyways, and Adam's going to
That,
approve.
boy, is that, I think that's
Yeah.
a lawsuit waiting to happen.
But just, those were some of the takeaways
Yeah.
I got, and,
I think that's, excuse me, part of the law now, regarding the HOA? Or is
Yeah.
that too big?
no, it's in the current language. Yep. There's a frequently asked questions section of the state website on it.
But there is.
And what else do?
Are there frequent answers?
I can send the link to John, and then
Yeah, that'd be
you
great.
can send it out to everybody if you want. That way I won't be.
The more you uncover on this stuff,
Yeah.
confusing it
It's just a
becomes.
mess. Yep.
A
It's like an onion.
A municipality isn't exempt, but an HOA is.
Yeah.
How does that work?
Now, on the bylaw that we submitted to the state, how many things were rejected on it? Not many?
Well, I can tell you a couple things off the top of my head. One thing that was rejected was, these are supposed to be allowed in every zoning district where residential is allowed. So initially, the use table doesn't allow ADUs in the village business district, but it has to be allowed in the village business district because residential is allowed there.
okay.
So we have to change that to being allowed in the village. So it's not heavy lifting. There's one that they didn't like, for instance, the stipulation they had that these ADUs, a structure for an ADU, has to conform to the dimensional height requirements for a single-family home. They didn't like that, so we're just going to change that to say it's going to have to conform to the regulations of the zoning district in which it is situated, and that's okay. Because they view that as being too restrictive.
Yeah.
Because, so in other words, so it has to be commensurate to the zoning district it's in. And another one was where it says if you have an ADU on a pre-existing non-conforming structure, you have to get a special permit just like everyone else.
No, they're saying
The state doesn't like that. So what Ken and I talked about with town council is this way around that. You just strike that and you stay silent on it. And then when someone comes forward with an ADU on a pre-existing non-conforming, you have them go for a special permit just like everybody else. So you just stay silent on it.
Will that be accepted, or that open up the town towards a suit?
Not according to town council.
Okay.
So those are three that I can think of off the top of my head.
So there wasn't really many?
No, nothing big.
Nothing, all just
Tweaks.
little
Tweaks.
verbiage?
Yeah, I think there may be one more, but I think that may be the only three or not much more than that. So,
All right. No, I'm just looking at going forward, the town meeting again. Are we looking at a whole barrage of changes? or just?
No, and that's why I wanted the two different articles.
Okay, yeah.
Because that is really house clean. House clean.
Yeah, good. No, that's
Yeah.
perfect.
What's really puzzling is these ADUs can be rented at market.
Yes.
How does that help low and moderate income?
It doesn't. And that's why it's under the Affordable Homes Act, but like you said, there's no affordability requirement attached to them.
And I thought that was their intent, and it certainly doesn't help our cause to meet those numbers. You know?
Yes, absolutely. Everything, you're spot on. Everything you said is exactly right.
All right, enough with ADUs. Meeting minutes, we have 2 in our packet. Three.
Yeah. There's 3.
We have 3 in our packet. Any issues with any of them?
On the September 10th one, I just saw on page 2, the first line, the area can be farmed and have livestock, not livestock.
Okay.
See that?
Yep.
Oh, wait, these are signatures that have to go on.
Oh, I thought,
I can't take that.
No, I've got his. His is right here.
okay.
All right. So one modification under September 10th. Care to make a motion on it?
I'll make a motion to accept the minutes of the Wednesday, September 10th, 2025 planning board meeting with the adjustment,
The amendment.
the amendment.
Second?
Made by Ms. Schlesman, second by Mr. Rose. Any further discussion? All those in favor?
Aye.
Did this come my way?
Who's going to add
Did you already see this?
Ernest? I don't know if he was on that one. The top.
Perhaps.
No, oh, it's absent?
Yeah.
All right.
Yeah, so for October 8th, adding Ernest Marks as excused. Gets confusing because he hasn't been in for a while there.
Under additional business, Ken Fraser, building inspector, gave his update and stated that when he visited the site, it was greatly improved and is happy with what is moving on the site currently. I don't know what that is.
Is happy with, I would just say happy with the site currently.
Or what is progressing?
Either of those things are.
Circle that. I'll entertain a motion to accept the meeting minutes for October 8th, 2025 as amended.
So moved.
Made by Mr. Preston, second by Ms. Schlesman. Any further discussion? All those in favor?
Aye.
Aye.
November 12. This is a quick one. John was absent. I don't see anything crazy jumping out. All right, I'll entertain a motion to accept the meeting minutes for November 12th, 2025.
So moved.
Second?
Made by Ms. Schlesman, second by Mr. DeRose. Any further discussion? All those in favor?
Aye.
All right. And with that, I'll entertain a motion to adjourn.
So moved.
Made by Mrs. Wicker, second by Mr. Preston. Any further discussion? All those in favor?
Aye.
Yep.
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 All right, we are adjourned.